In this session, we're going to focus on several basic estate planning concepts so you can better understand how this process works. Let's begin with you, or the both of you if you are married. All of us have an estate because many of us own real property, like your home or other real estate. We all own personal property, like automobiles, furniture, jewelry, computers, etc. And we also have titled property, like bank and brokerage accounts, life insurance, retirement plans, and other financial instruments. All of these make up your assets. So we will call this the A component. We also have heirs or beneficiaries. Typically, these are your children, those who you want to receive your assets after you pass. This could also be a charity like your church. So we will call this the B component. The objective of an estate plan then, after our passing, is to make sure A gets to B. Pretty simple. However, there is sometimes conditions. A condition may be a future uncertain event or a known event. In either case, something needs to be done. As an example, if one of these beneficiaries were only 12 years old, he would be unable to receive your assets until he reached a certain age, usually 18 or above. Therefore, a provision would need to be made to allow for this. So we will call this the C component. One more point. In addition to affecting a beneficiary, a condition can affect the individuals setting up an estate plan and how assets transfer. Okay, now we can see that the objective of an estate plan is to get A to B and take into consideration C. In our first example of getting A to B, we'll look at what most people do, which is nothing. About 60% of adult Americans do not even have a will. When a person dies, assets need to have a way to transfer to a beneficiary or heir. Certain types of assets are designed to transfer directly to a beneficiary. These would be life insurance and retirement plans like an IRA. For other assets, the default way of transferring is through a will. A will is processed by probate. This is usually done in a court. If you do not have a will, the state provides one for you. It will say who gets your assets. So assets may not go exactly where you would like. However, if you have a will, it will usually be used. Typically, the cost of probate can range from 1% to 8% of the value of the assets being probated. This could be several hundred to several thousands of dollars. One noted elder law attorney has stated that today, the cost of court proceedings may be expected to be in the 5-figure range. Additionally, it usually takes several months to complete the probate process before final transfer of assets. Clearly, this is not a very efficient or cost-effective way to get A to B. Today, many attorneys recommend the use of the Revocable Living Trust as perhaps one of the best ways to get A to B while considering C. Let's take a look how this works. When you create a revocable trust, you become the creator. This means you set up a trust and you can say how your assets transfer, when they transfer, and who will get your assets. Next, you are a trustee. This means that you hold title to the assets that are in the trust. This is why you transfer all your assets into your trust. Your real estate assets, your personal property assets, and your titled assets. Now, all these assets are structured to transfer directly to those you have selected. Additionally, you are the beneficiary. This simply means you continue to use and enjoy all your assets. Finally, there needs to be selected a successor trustee. This is one who will implement your instructions if you become incapacitated or when you die. Normally, adult children are chosen for this position. The successor trustee can also be a trust company. When one of you dies, typically there is nothing that needs to be done. In some cases, the trust may be split into two subtrusts. This has been done traditionally to minimize estate taxes. However, today the federal estate tax exemption is over $5 million, so for most people this is not a concern. When the surviving spouse dies, the successor trustee takes over and follows the trust instructions to distribute the assets to the beneficiaries. However, if there is a condition, such as the beneficiaries are still minors, the trustee will hold the assets in a holding trust and pay out income from the trust and principal for only certain situations, such as a college education. This is primarily how a trust can handle a future condition that would apply to a beneficiary. Let's take a look at some other conditions that could apply to you and what documents are usually used. The first is distribution. Usually, and what we have already seen is that the revocable trust has the capacity to handle the multiple conditions that might arise in the distribution process. Next is incapacitation. Durable powers of attorney are designed to select a person to act on your behalf to make decisions if you become incapacitated. There are two durable powers of attorney. One is designed to select a person to make financial decisions if you cannot. The other allows a person to make medical decisions if you are incapacitated. If you go into a comatose state, the living will and advance directives can be used to state your wishes about being kept on life support systems. Finally, if you forget to transfer an asset into your trust, there is a last will, sometimes called a pourable will. This will directs any assets you may individually own to go into your trust. This allows all your assets to be distributed to your beneficiaries the way you want. Assets that flow from the will to the trust may be subject to probate. This is why it is important to transfer all your assets into your trust. In conclusion, now you can see that the objective of getting A to B, assets to beneficiaries, while taking into consideration C, conditions, actually requires several documents. We provide all these documents plus other benefits, a cloud account, and important administrative procedures in what we call the Dynamic Trust Portfolio. Thank you very much for your time.